Dumela. We are going to start asking you questions essentially about pre the TRC and post the TRC period. And in so doing, I would want you to respond to what I'm going to put to you as the evidence that was given by Reverend Chikane and Ntate Pikoli, to see whether you agree or disagree with the statements that they made in front of this commission.
Yes.
Firstly, when Reverend Chikane spoke and gave his evidence, he talked about the many compromises that had to be struck.
Yes.
If you recall, it was essentially a war of attrition between two parties, the freedom fighters, including the people in South Africa, and the apartheid regime. So he said that when all of that was over, there had to be sacrifices because we had to move into a transition, into a reformed and transformed society. And that was a negotiated settlement. There was no winner takes all. And that was the context of the arrangements between the warring factions, as it was. You agree with that?
Yes.
And you'd also agree that the truth and reconciliation process was a mechanism to prepare the road ahead for the parties who had fought against each other, bitterly for that matter. You would agree with that?
Yes.
So when giving his personal account, Reverend Chikane would say that it was not a technical issue about charging people, but to get to the truth. That was his view of how he felt the TRC process would have tried to do, to tell the truth, for the perpetrators to tell the truth so that the victims would know what happened to themselves and to their loved ones.
Yeah, I agree.
I am not referring specifically to the record, Chair, because I'm assuming this is common cause, unless I'm direct you to where Reverend Chikane says these things. It would be in his evidence, the transcript of the 23rd of May. And that really there were conflicting interests, and it was a complex set of circumstances, and we were dealing with a fragile transition and political complexity.
Yes.
And that people had differing ideas of how we were going to make this all work.
Yes.
There would be those who say, let sleeping dogs lie. Ntate Commissioner Kgomo said it in Setswana, I can't remember the words. But there were those who were insistent that the truth must be told.
Yes.
And therefore, again speaking personally for himself, he thought that he couldn't accept that sleeping dogs must lie, because he wanted to know what had happened to him himself, who had poisoned him, under which orders, and why he was poisoned.
Yes, that's understandable.
And you were at a point involved in the prosecution, or trying to bring those who had done this to him to account. Therefore, you'd understand the sentiments that he espoused.
Yes.
At the same time, you got the evidence of Ntate Pikoli, who also talked about the dilemma of having emerged from the conflict, and that the defenders of apartheid were on one side and the fighters against apartheid on the other, and that we had a very fragile peace in South Africa. And for him, it was a matter of national concern. You'd accept that too?
Yes, I accept that.
And he mentions this in his transcript of the 12th of March, 2026. So at the end, you'd also then accept that in this context, there were sensitivities and political complexities, because on the one hand, you had perpetrators of acts of violence who killed, tortured, and assassinated their victims, and on the other hand, you had victims who sought justice.
Yes.
And this then leads us, Ntate Ramaite, to the president's speech. Did you hear the president's speech? Were you told of the president's speech?
I did not hear it, but I do think that at some stage A copy was obtained by the NPA, a copy of the speech.
Did you read it?
Yeah, well, I mean,
Can I essentially summarize
Yes, yes.
what the president was concerned about?
That's fair enough.
That the president was really saying that the business of the TRC was not complete. That there were people there had been hope that everybody would come and tell their story, what they had done, so that the victims could find closure. But in essence, people were not granted amnesty. And those that were not granted, on top of the fact that those that were not granted amnesty, there were many of those who didn't come forward to
Yes.
come and
Yes.
so you accept that.
Yeah.
And Reverend Chikane also, in his evidence, made reference to the speech, and Advocate Pikoli also made reference to the speech.
Yes.
And they understood what the president was saying and what the president was trying to say going forward. We need to look at post-TRC, a pathway for post-TRC matters.
Yes.
You have a look on your face. Do you agree?
No, I'm trying to get the gist, to the gist.
The
Actually.
gist of the speech.
No,
or
no,
the
no, I
gist
got,
of
I
what
got,
I'm saying.
I got that.
Okay,
yeah.
okay. And Advocate Pikoli then tells the commission that there had to be found a way of giving content to what the president has said,
Yes.
and a pathway forward.
Yes.
Therefore, having laid...
Dr. Ramaite, don't quickly say yes. I think you must wait until the full question has been asked. It may become a bit confusing when the yes comes too soon.
Thank you, Commissioner. I'll do that. I'll do that. I'll try to do that.
And I'll try to give you time to internalize the question and then give me an answer.
Yeah.
Fair enough. So if we go to the minister's call to you, if you recall, Minister Mabandla, the 4th of November 2004 call.
The call to me.
To you.
Yes, yes.
Thank you.
I remember that.
Yeah. The minister told you that there was a task team which was appointed, and this task team would be the DG's forum to develop a mechanism to deal with TRC cases.
Yes.
That's what you're supposed to take your time.
Oh. Yeah.
You and I are the same. I don't take time. If you agree with me, you agree with me. It's not a trick question. So
No,
you
no,
can
no.
decide.
I get that.
Yeah.
At times, I'm trying to figure out where the question ends. You see, so that's what I'm trying to
Fair
get.
enough. Fair enough. Fair enough. The minister told you that there were guidelines that were being formulated, and that this committee of directors general is busy with the guidelines. She told you in this phone call. Should
Should I answer?
Yes.
Yes, it's correct.
And one of the directors general was Mutani Ramait, my ex-partner.
No. I did not say that he was. I said, in my evidence, I said, I knew of the Directors General Forum. Now, I knew about its existence because at some point, my younger brother was Director General and he was chair.
Of the forum.
I did not.
Oh, so
Yeah, there was no evidence of him being involved at all.
so the minister didn't mention that forum
No.
in the telephone call.
She said there was a mechanism, guidelines that were being developed by directors, a task team of the directors general.
Okay. All right.
Not, and my understanding, I did not understand her to mean that it was all the directors general. I understood him to mean that there was a task team
Yes.
consisting of certain directors general.
Agreed. So if I can direct you then to the 13th of November, you had a consultation with Ntate Seminya,
Yes,
and you were talking about this telephone call
yes,
with the minister. And you were asked whether you were instructed not to arrest the accused in the Chikani matter.
yes.
And your response was, the minister did not instruct me to not arrest. And if I can, it would be helpful if you could go to that affidavit, because I'm going to ask you a number of questions on that affidavit.
To my affidavit?
Yeah. It's
Okay.
a transcript of the affidavit, and it is at page 48
I would not
of
know.
the
Is it in
paginated,
this?
but page 19 of the document itself.
This is in this?
The outside is written consultation.
I did not get a chance to familiarize myself with
Who will help?
the file. Can you help me? Yes.
Our apologies, Chair. Apologies, Chair. We had listed it and we had indicated to our young gentleman at the corner there that it's not in the file. My apologies.
Oh. Yes, I think I have it.
And if you were to go to page 19,
That's
the middle of the page,
sorry. Page 19.
it's at the top it's 48, but in the
Yeah,
middle
yeah,
of the
you
page
can
is
see
19.
that, yes.
Yes. And in the middle there you say, Dr. Ramite says, no, she did not instruct me not to arrest. She said there is a committee of this Directors General that is busy with guidelines regarding the TRC matters. You recall saying that?
Yeah.
And then, when you testified on the 23rd of February, do you have your transcript there?
Is it part of?
It will be on the 23rd. There's a transcript page.
You see the difficulty, it's going to take some time because I did not
No,
have
it's
time
okay.
to familiarize
Just sit
myself
here,
with the contents of the file.
Sorry. Apologies about that. Oh, my. Apologies. So what we're going to do, Tatiramate, is we're going to look at your interview, as it were, the consultation of the 13th of November and your evidence of the 23rd of February.
Okay.
Page 30.
Okay.
30.
Page 30 of the transcript.
30.
Yes, Commissioner. And it will be lines 9 and 10.
9 and 10. Oh, yeah. So she gave you an order to stop, and then I say an instruction.
Yes. And then after the call, because of what had transpired with the call, you then have a conversation with Advocate Ackerman.
Yes.
And you tell him that because of the uncertainty regarding how to go about or how to proceed with the matters, that it's better for you guys
us to wait.
To wait.
Yeah.
Okay. Now, again on the 26th of November, you state that your understanding was that an effective moratorium was in place.
Yes.
But on the 13th of November, if you go to your statement of the 13th of November, when you were questioned by the evidence leaders, you say you were clear. If I can go there, because I see your look, if you can go to your statement at page 25, line 20, page 25, line 22.
Now, which statement is it? No.
The 13th of November statement. Remember I said we are going to juxtapose the two
Yeah, yeah.
statements. Yeah.
Oh, is that during the consultation?
The consultation,
Yeah.
sorry, yes, the
Oh, all right,
consultation
okay.
statement.
Get opened. Page?
Page 26, line 14. You say there that the word moratorium had been an unfortunate use of the word moratorium. You see that?
Can you just tell
Hold
me
on, sorry.
the line again?
The line is line 14.
Where I say, yeah, look. Is that?
You can read it?
That, yeah, look, that is why I'm saying it might have been an improper, I do not know, an unfortunate use of the word moratorium.
Don't close the page.
Yeah,
Sorry,
okay.
don't close it. Because you then proceed and you say what you meant to say that, and this is at line 5 of page 31.
Line 5.
That what you meant to say is you should not proceed until the guidelines are resolved. You would agree that it was a pause.
Hang on, just give me the line again.
Line 5.
Oh, will that be a moratorium?
No, that would be a pause.
Oh, okay, let me just go through it.
And Advocate Smia says, let's use the word pause.
Yes, I see that.
You see that. And then you, again, on the very same statement, you tell the evidence leaders that let us stop, let us not proceed with these matters, but they continue doing an assessment of all the cases they had. In fact, even looking at the Chikani matter.
Yeah.
You recall saying that?
Yes.
Okay. So in essence, you pause prosecutions while these were paused, those responsible for the TRC matters continued to assess them. Would I be correct to say that?
Yes.
And that is why in your affidavit dated the 26th of November that you filed with the Commission, you tell the Commission in that statement that you filed with the Commission, you state that during 2003, 2004, and 5, the PCLU identified a number of TRC-related cases for further investigation and possible prosecutions. You
Yes.
say that in your affidavit of the
Yes.
26th of November. Yeah. And then you say that at the statement of the 13th of November, you again say you explained to Advocate Smenya that Advocate Ackerman may have misunderstood you, that you did not mean discontinue. You wanted to avoid any conflict with the minister. That is what you said.
Where is that?
Find it just now. I'm referring to the statement of 13th November.
13 November. Where is that now?
And we're looking for it. I think it will be on page 16. That would be at line 8, 9, 10.
What page?
The page, sorry, page 16.
It's 16. Line, sorry.
And it starts, the paragraph starts technically.
Yes.
All I wanted, I do not know whether we misunderstood each other or whether we misunderstood each other. But all I wanted, and you remember at the time I was acting, I wanted to avoid this conflict between the responsibility of the minister and I take it yourself.
Yes.
And that it may be that you and Advocate Ackerman misunderstood each other.
Let me just.
Because the issue starts on the previous page.
Yeah.
Would I be correct in saying that?
Yeah, whether we understood or misunderstood
Understood each other, yes. Thank you. And then you say again on that very same affidavit, at page 32, line 2,
Yeah, where I say, no, that decision is not made by you, by someone outside. That decision is made by me as acting NDPP. Yes.
thank you. So now if we can move to the policy directives themselves.
Yes.
And again, you're still at the same affidavit. You tell.
What page?
Page 19,
19. 19.
19.
Yeah, all right.
You tell the evidence leaders that you expressed discomfort with the manner in which it might border into interfering with prosecutorial decision.
Yes.
And you raise a concern with the minister.
Correct.
Because in your view, there was already a policy in place that covered everything.
Exactly.
You did not relate this to the president's speech where he said there are outstanding matters that still need to be looked into.
No, not at all. And remember that this arises from, the minister saying to me that there's this committee that is busy developing policy guidelines, specifically in relation to TRC matters.
Yeah, what I'm trying to say to you, or maybe let me put it this way, Mr. Piccoli was of the view that there's a link between what they were doing and the president's speech. I'm saying for you, during that telephone conversation, there was no such link.
No, for me, no.
And that is why there's a difference between yourself and Mr. Piccoli, because when Mr. Piccoli gets asked about why is it that these guidelines are being formulated, would he consider that as an interference? And he says no.
Yeah, well, I wouldn't have thought about that, because at that stage, when the minister called me, so basically we had to wait for the guidelines. It was only when the guidelines were actually published that that we got to know what they entailed.
What I'm trying...
And indeed, they in essence confirm my concern that it might border into interference with prosecutorial decision making.
The point that I'm trying to get to, Tate Ramaite, is that when this telephone call, the conversation between you and the minister happened,
Yeah.
you did not know of the president's speech. You hadn't heard of it. You hadn't read it.
No.
And can I refer you to what Reverend Chikani also says about trying to prepare guidelines? He says this in his transcript. I think you have Chikani there, but I can just read it to you.
Sure.
Yeah. Because his evidence is that the guidelines were being developed to allow a possibility of those who were prepared to disclose what they did to arrange for plea bargaining and sentencing arrangements to dispose of their cases, and not as a general amnesty or an interference, and not to go ahead with prosecutions. Do you understand what he was saying?
I understand it, but I do not necessarily agree.
Correct.
In fact, I do not agree.
Yes. So you and Advocate Piccoli on this issue do not agree. Would I be correct? The issue that he was the driver of the guidelines, he found that there was nothing wrong in drafting those guidelines. You thought these guidelines were incorrect, they shouldn't be drafted. That's the essence of the difference between the two of you.
Yeah, to the extent that they specifically applied to, the
TRC cases.
Yeah, TRC cases.
You differed.
Yeah.
He says that he found nothing mischievous about the fact that maybe let me put it this to you, that he found there was nothing untoward about the president's speech. You can't comment because you don't know
I
about
cannot
it.
comment
Yeah.
on that.
And also that he had you've already said it, he said he had no discomfort with the development of the guidelines. You've told the commission that you differed. I'm correct in that. There's
Yeah.
nothing wrong with two lawyers differing.
Yeah, I mean, my view, and then that is once the guidelines were published, my view, and I expressed that view at various meetings of the executive committee, was that they were likely to be unconstitutional.
And I would imagine in those interactions and in those conversations, Advocate Piccoli differed with you.
Well, I mean, I do not recall. I cannot remember him voicing any view. But I mean, obviously, what I do know is that Ackerman actually agreed with me.
Yes. That's what I'm saying. I'm saying you and Ackerman on one side agreed with each other. Piccoli did not agree with you.
Well, I mean, I'm unable to express a view on that, but
Were you not in those meetings? Was he not there?
Well, remember that advocate, and I think we must make a distinction between the period when I was acting NDPP and the period, I think, from February when Advocate Piccoli was then and DPP, and those guidelines actually came out during Advocate Piccoli's tenure as NDPP. And in fact, well, okay, sorry.
What I'm trying to get to, Ntate
Ramaite.
Ramahiti,
Yes.
is that you had conversations in the executive amongst yourselves as the executive.
Yes.
You are saying you and Ackerman had a similar view on these issues, on the guidelines.
Yes, that's correct.
I am saying to you, Pikoli had a different view.
I cannot remember him having a different view, unfortunately.
And therefore, I was asking the question, did you not have meetings where he was involved as an executive, as a leader of the team, where all of you spoke about these issues? That's really...
We did express, I and Ackerman did express.
That I
but-
understand.
but what I'm saying is I cannot remember him disagreeing with our view.
He was the driver of the other view, was he not?
I cannot remember him being the driver of the other view.
Ms. Morocco, I'm getting a bit lost now. If you say to Dr. Ramaite they differed in approach, you may have put that statement of Advocate Pikoli to him. Maybe we must go to it again, so that, at least for myself, so that I can try to make out whether there is in fact a difference. And as I sometimes say, you find that there is a difference without a distinction.
There was a fundamental difference, and that's what we're going to argue. But I will, Commissioner Khomu, take Mr. Ramaite to
Yes.
the transcript by Mr. Pikoli. And it was not about the content, it was about whether they ever discussed this issue.
Yes, let's go there.
Can we go to the transcript at line 10?
Which
I'm
transcripts?
sorry, Pikoli, the 7th of May.
Oh, no, okay, I'll have to. Is it this the 7th of
May. Do you have it there?
which transcript now?
You will get help
I
soon.
have 12th of,
No, not the 12th, the 7th of May.
right. I should have familiarized myself with this, but then it's gonna.
No, there are too many, I think.
Yeah, had I
be
familiarized
fair.
myself, at least it would be much quicker for me. Okay. 7th of May, yeah, I've got that. What page, sorry?
Shall we start off at page 3,
Page 3.
line 21?
Okay. Okay, I can see that.
And then if you go to, Ntate Khomu, you are there.
Yes, but for the purposes of the record, can that just be read?
Can you read line 3 then? Page 21. No, I'm sorry. Page 6, lines 17 to 23.
Which one is it? Is it page
Same,
3 or
same,
6?
same.
No, it's
No,
page.
you were
Can
at
I
page-
say the first, page 3 was about Mbeki's speech. Then he goes on at page 6.
Yes, but Ms. Morocco, what I'm saying is that the witness says he sees it, but does the record see it if he does not read it?
No, I'd given him the wrong page because
Oh, okay.
it's where it starts. It starts with Mbeki's speech, and then the following 3 pages that follow, he talks about Mbeki's speech, and he goes to page 6, lines 17 to 23. Are you there?
Okay, yeah, I see that.
So line 17 would start with, yes, I did not have a problem. Is that so?
Yes.
Yes. Can we read that?
Okay, it reads as follows, I quote, yes, I did not have a problem with that because I thought it was a question of trying to accommodate the outstanding TRC matters which were not attended to during the life of the TRC. Therefore, a mechanism had to be found to deal with those outstanding matters. So I felt that for as long as they fall within the Constitution and the law, then there will be nothing wrong in amending the prosecution policy.
Thank you. We then move on to page 10.
Yes.
Line 23.
Line 23. Yeah, it takes me back to what I've always been saying, starting with the policy statement that was made by the President in Parliament in 2003, that everything had to be done within the framework of the law and the Constitution, and therefore the question of amending the prosecution policy was seen as a mechanism to be able to allow the process to go forward.
Thank you. And then if you go to page 23. And that would be line 11. Sorry, page 10, line 23. To page 11, line 14. It's a long one. I don't think we need to read
We
all
have
of
read
it.
that. We have read that.
Oh, that's what we've just read.
Yes.
Thank you. So the question, even though I didn't want to get into the substance, but we've gone into the substance. The question was that all I'm saying is that there were differences between yourself and Epicoli, and you are saying you do not recall that there was a difference, or you do not recall the conversation where the differences were debated between the two of you.
Yeah, my understanding, and I think that's what Mr. Piccoli is referring to, he's referring to at the time that he was at the Director General, and not at the time that he was NDPP. So,
No,
I mean,
he
I
was
thought-
NDPP.
Sorry?
He was NDPP. Because remember, when he moved from being a Director General, he went to become the NDPP. And this process was completed during his tenure
Yes,
as NDPP
yes,
In 2004.
in 2004.
that is correct, yes.
So I'm not sure that your statement is correct.
No, but if you look at what you read, I think is referring to what the President said in 2003.
Okay, maybe then go to page 6,
Page 6.
lines 17 to 23.
Yes, I did not have a problem with that because I thought it was a question of trying to,
No. Where it says, I became the NDPP.
page 6.
Page? Page, is it page 7 or page 6? My apologies, it's page 7. He became the NDPP in 2005.
Yes.
You're at line 10. Is it?
I'm at line 10. So you see that even as the NDPP, the work continued.
Yeah.
And his view on what he was doing was different from yours.
Well, again, it's a question of the time, you see, because after he became NDPP, I do not recall him actually differing with us.
Ms. Moroka, at an appropriate time, you will indicate so that we can adjourn for tea.
Well, if you can round it up,
Yes, you may.
Commission pleases. So if you, we took you to line 10, right? But if you go to line 1, 2, 3, 4, 5, line 15,
What page?
the same page, page 7.
Page 7, all
Yeah.
right, okay, 15.
Yes.
10, 1, 2. No, certainly at that time I did not see anything wrong with that. I actually supported the process.
And you understand what the process is.
Yeah, I think it's the process of amending the policy.
And all that I'm taking, all I'm asking you without taking it anywhere, Mr. Ramaite, is just to say you and Mr. Piccoli differed. He even gave evidence and told us if I could take you to his transcript again on the 13th of March, which is my final question on Scott's honor.
Yes.
Sorry?
Transcript Piccoli, the 13th of March, page 159.
13th of March, page, sorry. Page?
Page 159.
Yes. What paragraph?
Line 20.
20, okay. All of us sitting here, we are lawyers. You can put 10 lawyers in a room and perhaps give them the same set of facts, but it is not improbable that you might get 10 different answers. It is not about that. It is about the truth. This is about making a determination as to into who was responsible for the absence of prosecutions when the law was quite clear.
So you see that he did differ with you, and there's nothing wrong with lawyers differing.
Yeah, well, if that is what you are saying, but
No, that's not what I'm saying. That's what he's saying.
well, I'll accept that.
Thank you. Those are the questions, Chair.
Thank you, Ms. Moroka. We'll take a tea adjournment and reconvene at 11:20.
It's just some legal propositions that I think we can agree on.
Yeah.
So, Section 179(1)A establishes a single national prosecuting authority headed by the NDPP, appointed by the president. We can
Yes.
agree on that, yes.
Yes.
And then Section 179(2) provides that the prosecuting authority has the power to institute criminal proceedings on behalf of the state. And you accept that this power would be vested on an NDPP or an acting NDPP?
Yeah. That's correct.
Yes. And then Section 179(4) of the Constitution provides that the national legislation must ensure that the prosecuting authority exercises its function without fear, favor, or prejudice.
That's correct.
And we agree that then the legislation referred there would then be the NPA Act.
That is correct.
And then we move to Section 179(5)A,
Yes.
which basically says the NDPP must determine, with the concurrence of the cabinet member responsible for the administration of justice, and after consulting the DPPs, and I'm shortening it because it's Director of Public Prosecutions, prosecution policy, and then Section 179(6) of the Constitution that the cabinet member responsible for the administration of justice must exercise final responsibility over the prosecuting authority.
Yeah.
And we accept that would be the Minister of Justice.
That is correct.
Okay. Now, can we then look into the NPA Act? You should have a copy
I
in
have
front
it.
of you.
Which sections?
We'll start with the preamble.
Oh, all right, okay.
It just always makes life slightly easier to start from the beginning. It would be the second page. It reads as follows. And whereas the Constitution provides that the National Director of Public Prosecutions must determine, with the concurrence of the cabinet member responsible for the administration of justice, and after consulting the DPPs, prosecuting policy which must be observed in the prosecution process. That is what the Act
Yes.
says. And then can we now move to Section 21?
Yes.
So, Section 21, 1. I'm loath on reading this whole thing. And I'm looking at Commissioner Khomo for the record purposes. Is it okay if I just ask the witness to read Section 21 of the National NPA Act?
Both
And then-
sections.
Yes.
Okay. 21(1), the National Director shall, in accordance with Section 179, 5A and B, and any other relevant section of the Constitution, A, with the concurrence of the Minister and after consulting the Directors, determine prosecution policy, and B, issue policy directives which must be observed in the prosecution process and shall exercise such powers and perform such functions in respect of the prosecution policy as determined by this Act or any other law. Subsection 2, the prosecution policy or amendments to such policy must be included in the report referred to in Section 35(2)A, provided that the first prosecution policy issued under this Act shall be tabled in Parliament as soon as possible, but not later than 6 months after the appointment of the first National Director.
Okay. And then can we go to Section 22(1)?
22(1), the National Director, as the head of prosecuting authority, shall have authority over the exercising of all powers and the performance of all the duties and functions conferred or imposed on or assigned to any member of the prosecution authority by the Constitution, this Act, or any other law.
So do you accept from what we've now read that the NDPP or acting NDPP would bear the ultimate responsibility of the NPA?
Yes.
And do you also then accept that an NDPP, and I'll use NDPP whether it's acting or
Yeah.
not for purposes of this, would then also have the ultimate responsibility of determining what gets prosecuted and what doesn't get prosecuted.
Yeah, perhaps, well, I mean, I don't know if I should, because I'm trying to figure out, you see, because the national director himself does not conduct prosecutions.
Yes. But whether a decision, a final decision on that aspect would lie at, we've just read through what his responsibilities are, or her responsibilities. The current one is a he, yes. What the responsibilities of an NDPP would be.
Yes, that's correct, yeah.
And that would include the process that needs to be observed, one, in the prosecution.
Yeah,
And secondly, he would in fact have the final, he has the power and authority to exercise all power and functions in relation to the NPA.
yes,
And therefore, he would then have the ultimate responsibility to determine whether or not particular policies are passed within the NPA or not.
yes,
And that includes policies to prosecute
Yes.
or not. And then, can we then move to section 32(1)(b)?
I don't have, unfortunately, do you have a copy of the full NPA? I don't.
It should be in the bundle, but I will
Where?
give you my copy.
Where?
You can have my copy. It is clear
Section 32,
1B.
yeah, impartiality of, and 1B.
Yes.
Subject to the Constitution and this Act, no organ of state and no member or employee of an organ of state, nor any other person shall improperly interfere with, hinder, or obstruct the prosecuting authority or any member thereof in the exercise, carrying out of, or performance of his or her powers, duties, and functions.
Okay. And we agree this is the law.
Yeah, that's the
And-
law.
And then can we go to I think I've given you the, and in terms of the very act, if you look at section 41, 1,
41 offenses and penalties.
yes,
Any person who contravenes the provisions of Section 32, 1B shall be guilty of an offense and liable to, on conviction, to a fine or to imprisonment for a period not exceeding 10 years, or both such fine and such imprisonment.
So having established firstly the duties of the NDPP and now having gone through this section, would you agree that the NPA Act places a duty on an NDPP as the head of the NPA not to permit any interference with the work of the NPA?
Yes.
And goes further, in fact, to actually put a positive duty to do something if there is any interference in that regard, because it criminalizes the interference.
Yeah, well, but I mean, that will ultimately, you see, and then that's where the catch comes in. That will ultimately depend on the NDPP himself having to decide.
Yes.
Yeah, that is correct.
And when should the NDPP decide?
Well, whenever there is either an allegation or it appears to him that there has been contravention of the section. You know, but whether in any given situation that decision will be taken, it's not a given.
Okay, can you just expand on that? When you say whether in any situation that decision will be taken,
Yeah, you
is
see,
not a given.
it depends. It depends on different circumstances. I mean, for example, it will be easier if it's just, let's say, and look, I mean, that would be possible. But in fact, to be fair, in my experience, I'm not aware of any instance where that section has actually been used.
And so then in your experience, why wouldn't it be used if there is allegations? of interference, or if there is interference?
It depends on the culprit. If I were to put it, if I were to put it in that way, our experience has been cases like this are not easy. In fact, the likelihood would have been that it would create even more tensions within the NPA.
So, what then gives leeway to the other? What the law requires of the NDPP, or the NDPP making the decision themselves to say, well, look, I don't think this is serious enough to warrant me actually utilizing that?
It did not mean that it was serious enough. I think it was probably, one having to seriously consider whether it was worthwhile.
Ms. Ntoko, you are theorizing, are you going to refer to specific incidents so that we can see whether this falls within the terms of reference? Because it's all theory.
Commissioner Homo, I'm not sure it is, because we are here to, firstly, the terms say that if there's interference with the NPA.
Okay, you're now going to demonstrate that it isn't theoretical. Carry on.
Oh, no, the NPA does not know anything about interference, Commissioner Homo. I think I should put it on record. We have said this over and over again. So this is us trying to establish what would happen, firstly, if there is interference, as we understand it, and then secondly, what would have been the steps. So I cannot, in all fairness, establish interference.
I've said carry on.
Thank you. So during your tenure, this is my last question, Dr. Ramaide. During your tenure, if there was interference, what would have then been expected of you as the acting NDPP?
It would, as I said, it would have depend. I mean, it would depend on the circumstances of the interference. I mean, I cannot speculate, because, I mean, I would have to decide when confronted with the facts. But if I were to give you an answer, I mean, I would be giving you a supposition.
Okay, then I think we could ask then the blunt question. Were you subjected to interference during your tenure at the NPA? And if you were, what did you do about it?
I'm trying to be careful here again, because I do not understand what form of interference. I think it might be useful to be specific.
Well, I'm using the terms of reference, which is the Commission must, in relation to the period since 2003, inquire into, make findings, report, and make recommendations concerning the following, guided by the Constitution, relevant legislation, policies, and guidelines, whether, why, and to what extent, and by whom efforts or attempts were made to influence or pressure members of the police, that is for the police, I will not enter that, or the NPA to stop investigating or prosecuting TRC cases. Whether members, and then it's a long thing.
Yeah.
But we have established earlier, in fact, using the Act itself,
Yeah.
that says, subject to the Constitution, no organ of state or member of an organ of state, nor any other person shall improperly interfere with, hinder, or obstruct the prosecuting authority or any member thereof in the exercise, carrying out or performance of its or his duties. So then I think the direct question is, if you're reading section 32, during your tenure, did this happen where an organ of state or a member or employee of an organ of state or any other person, was there any person who improperly interfered with, hindered, or obstructed the prosecuting authority or any member thereof in carrying out their performance during your tenure?
Look, I mean, I acted 3 times, and the only and talking about executive, anyone from the executive, the only instance where I had an interaction with the executive was with the minister during my first acting stint with the minister when she called me, and in relation to the Chicane matter, and stated that they were in the process of developing prosecution policy and that we should, in the meantime, not proceed with the Chicane matter and other TRC matters. And at that stage, I did not regard, as any form of interference, because she had said that the reason for a request was that they were busy developing prosecution policy. And my attitude was to wait and see the content of the prosecution policy. It was only after I had seen the content of the prosecution policy that I formed the view that this would be improper.
Improper to, just to close off this, improper to fall within the definition of Section 32?
Well, I mean, I'm not so sure whether that would be interference, but the view that I formed was, I mean, to have the TRC cases decided well or discussed with the relevant directors general, in particular SABS and NIA, and then have them making recommendations to the NDPP. That, in my view, was improper interference in the independence of the NDPP, because it is only the NDPP who can make that decision and nobody outside of that sphere.
Okay, so if you're saying them making recommendations would have constituted interference, what then did you do about that? As
Well,
the
I mean, that was
NDPP?
during Mr. Piccoli's time, and in fact, that is what eventually disagreement about the approach in the prosecutorial decision-making is what ultimately led to a stalemate.
And then during your time?
No, not during my time. Not during my tenure.
But wouldn't, even if you are not an NDPP, if you then, as a member of the NPA, know about interference that falls within Section 32(1)B, would there be no obligation on you to act on it?
No, I did raise it with the NDPP and I expected the NDPP to take it up, which I understand, in fact, and I believe he did take up with the National Commissioner and the Director General of NIA.
Okay. And then, just then one last question. It appears, at the very least, from the NPA and every other witness here, that all matters that, let me just check quickly. And this is our last question. The only matters that were halted were during your tenure. Look, no other NDPP had.
Sorry?
All other NDPPs. Can I just ask this question? During your tenure, Ms. Memoroka, let me say Ms. because Memoroka, you had said that during your tenure, when you were informed.
Sorry, just come again.
When,
said-
when Memoroka asked.
Oh, yeah, okay. I
That
thought you were
during
addressing
your-
me as Memuroka.
And you are not.
It did sound like that.
Not at all.
All right.
I mean,
Apologies then.
have you seen how pretty she is? So,
Ask your question.
yes. No, when Momoroka was asking that during your tenure, you, just to close off, you still continued with investigations and reviewing of files in the NPA.
One needs to clarify that we could not proceed with investigations because the PCLU did not have investigative capacity.
Okay.
So they could not do any investigation, but they continued going through the dockets and identifying, the witnesses that may be required, and if any further evidence. So what one is saying is they continued working on the cases,
Yes.
even though in the hope that ultimately, investigative capacity will be available.
Thank you. That's all. I promise.
Thank you, Ms. Ntloko. Ms. Ranto.
I'm not going to make this. Oh, all right, maybe we can take this. Oh, okay.
Apologies, Commissioners. I'm just waiting for the bundle to be sorted out.
What pages are these? Yes. Oh, all right. Yes. Okay. Yes. Oh, all right. Okay. Thank you.
Good morning, Commissioners. And good morning, Dr. Ramaide.
Good morning, ma'am.
I'm going to canvass very few questions with you. I represent the South African Police Service.
Yes.
My last name is Ranto.
Okay.
Yes. You testified before the commission that you formed part of those individuals that were involved in the establishment of the PCLU. Is that not so? So you were there when the PCLU was formed or established?
Yes, we conceived the idea of the special, because it was formed as a specialized unit to deal with specific category of cases.
Yes. And in accordance with the proclamation that gave powers to the PCLU, the PCLU was clothed with investigation and prosecutorial powers. Is that not so?
Not investigation.
Okay. Perhaps if you may explain, because the proclamation says that, in particular, I refer to the one where Advocate Ackerman was appointed to head the PCLU. And it appears in the bundle 1456. Page 1456.
Let's see. Yeah, you see the bundle that I have
It's bundle 1.
starts from page, it's got page 1 up to 247, and thereafter it jumps to page 1698.
Bundle 8? You have bundle 8 in front of you.
Sorry?
Bundle 8.
The bundle that I was given is not,
Okay. Maybe.
no indication.
Okay, let me just assist. Sorry, Dr. Ramaide. It's something that is of common cause. It's a proclamation by the president, the one that was giving effect to the appointment of Advocate Ackerman to head the PCLU.
yes?
Yes. So, what? Okay, yeah, I just want to read out
Okay, sure.
to assist in the
Sure,
question that
sure.
I was. The proclamation reads thus, to exercise powers, carry out the duties and perform the functions necessary within the office of the National Director of Public Prosecutions as directed by the National Director, and in particular to head the Priority Crimes Litigation Unit and to manage and direct the investigation and prosecution of crimes contemplated in the
Yes.
implementation of this. So I just wanted to understand in terms of that direction or management and direction of investigation.
Well, it does refer to investigations, but the emphasis on the management and direction of the investigations. The investigations are not done by the PCLU itself. The investigations are done by the police, but then the PCLU manages and directs those investigations. In other words, the head of the PCLU or prosecutors in the PCLU will give directions to investigators as to what needs to be done. That is what it means.
Okay. Evidence has been led that PCLU never had capacity, and I think you just confirmed that during your examination by Ms. Ntloko, that there's never been capacity.
Investigative capacity. Yeah. Investigative capacity.
And the prosecution was their capacity in terms of prosecution?
Well, I mean, they were not enough, but initially, the personnel was there. I mean, there was Anton Ackerman, there was Chris McAdam, there was Tori Pretorius, and then there was Mtunzi Maga. So we were coping, but I mean, we would have welcomed additional prosecutorial capacity.
Okay.
The capacity that we're talking about is investigative capacity. That is what was lacking.
And what efforts did you put in place to ensure that there was investigation capacity?
I mean, there was a lot of effort, and I think Advocate Ackerman would have spoken about that, interaction with the police, request to the National Commissioner. But I mean,
No, particularly yourself.
sorry?
Advocate Ackerman was reporting to you, correct?
Yes.
Yes, and I want to find out from you, what measures did you put in place to ensure that there was investigative capacity?
I mean, I was, part of the efforts, and it was a collective effort. It was not an individual effort. But at the end of the day, ultimately, when we were not getting any assistance, we relied on the NDPP to persuade, SABC to provide the capacity.
What efforts were those, Dr. Ramaite?
Requesting the police. Yeah.
Specifically when and who did you direct the request to?
No, I did not personally.
Okay,
It was Anton Ackerman and the NDPP, as I said.
all right, thank you. Let's go to the decision to prosecute in the Chikane matter.
Yes.
It is common cause that already in November 2004, you had taken decision that the matter was ripe for prosecution, right?
Yeah, that decision was taken by me.
Yes. And then pursuant to that decision also, you decided that the prosecution would be suspended pending the development of guidelines, isn't it?
That is correct.
And then further in your affidavit, you informed the commission that pursuant to your engagement with somebody from the ministry, you took decision, it was also in November 2004, not to prosecute or not to continue with TRC-related prosecutions,
No,
isn't
that
it?
was pursuant to my conversation with the minister.
Yes. Would I be correct that at the time when you decided that the Chikane matter was ripe for prosecution, there was no need for further assistance in terms of investigation on the part of the
Yeah,
police?
I mean, the Chikane matter, we had already taken a decision. So there was no further investigation was required.
Now, if I may refer you to paragraph 42 of your affidavit.
I had it just here. Oh, it's should we? Oh, yeah, okay. Okay, I've got it. I'll find
Yes.
it. Don't worry. It's okay. Paragraph 42.
42 and 43, to be specific.
40? Sorry?
42 and 43.
Okay, yeah, the next meeting was held on 6 November 2006. The Chikane matter was discussed for the first time at this meeting. Mr. Lekalakala informed the meeting that the National Commissioner of Police believed that Reverend Chikane was not interested in a prosecution. Advocate Ackerman informed the meeting that Reverend Chikane had left the matter in the hands of the prosecution. The meeting ended without any resolution and with no commitment regarding the provision of investigative capacity. I reported the development and outcome of the meeting to Advocate Pikoli.
Now that the matter was ripe for prosecution, what investigative capacity were you expecting from the SABC?
No. See, you must remember that this follows the meeting, I think, of the 25th of October, the previous meeting. Now, at the previous meeting, an audit report was given by Advocate Ackerman. Amongst the matters that were reported on in terms of the audit report was the Chikane matter.
Yes.
And what was being said, what he was saying was, well, the Chikane matter is one of those matters where we're not going to need investigative capacity because the investigation has been finalized. But then there were others where it was clear from the audit report that we will need investigative capacity.
So it would be incorrect to say that what is stated in paragraph 42, in actual fact, it's not a true state of affairs.
No, it is a true state of affairs. As I'm explaining, that this thing arises from the report, because at the previous meeting, in his report, Advocate Ackerman had actually mentioned the Chikane matter, all right? And then he said, well, that matter, the investigation has been finalized, this not going to be. But then, incidentally and strangely enough, the Chikane matter then arose in the meeting in the meeting of the 6th of November.
Yes, but what I'm asking you is, there was no need for investigative capacity in relation to the Chikane matter, is that not so?
Yes, even if there was no need, but then it arose.
It may well have, but there was no need because the matter was ripe for prosecution.
There was no need.
Yes. And then if you go to paragraph 43,
Yes.
a further meeting was held in early December 2006 to try and resolve the impasse. At this meeting, Police Deputy Commissioner Jacobs informed the meeting that the National Commissioner was not prepared to provide any investigative capacity in the Chikane matter because Reverend Chikane had not been consulted and did not wish to become involved in any prosecution. You say then you reported to the NDPP?
Yes.
Yes. What I'm saying is that what is stated in paragraph 43 cannot be correct because there was no need for investigative capacity in the Chikane matter.
It is correct. You see, the Chikane matter arose for the first time in the meeting of the 6th of November. And it arose again in another meeting, and I think that was the meeting of the 16th of November. It was raised again. See, and then, so in other words, if I may put it in this way, the Chikane matter kept on arising, and it appears to me that it was actually the trigger of all these things.
We'll deal with that, Dr. Amaiti. My question was directed at that which you allege that the police were not prepared to provide investigative capacity.
Yes.
How so? Because the matter was ripe for prosecution.
No, but it was in relation to the other matters, to the other TRC matters.
But your affidavit specifically says the meeting, Commissioner Jacobs informed the meeting that the National Commissioner was not prepared to provide any investigative capacity in the Chikane matter because he had not been consulted. So it specifically spoke
Yes, but
to the Chikane matter.
Yes, but you see that is what he said, but that was not the true position.
So we can accept that
It is-
it is what is stated in paragraph 43 was not correct because
No, it is correct. I maintain that it is correct.
how correct is that, Dr. Amaidi?
As it appears, it is correct. It is correct because indeed, Commissioner Jacobs conveyed National Commissioner Levy's sentiment of view in respect
We
of
will
the
deal
Chikane
with
matter.
it.
But that was not the real issue.
Okay. I don't want us to really waste time on this point. We can agree that reference to a lack of investigative capacity in paragraph 43 cannot be a true reflection of what was the situation at the time because the matter was ripe for prosecution, isn't it?
No, I maintain that it's true, but it refers specifically to other cases other than the Chikane matter. The Chikane matter, in my view, was given as a, as a, what do they call it, as a red herring.
We'll deal with the Chikane matter. We'll deal with the minutes. But I think we will argue in closing that what is stated in paragraph 42 and 43 of your affidavit is contrary to what you informed the Commission that the Chikane matter was ripe for prosecution as far back as November 2004. And I don't want us to argue any further.
I'll accept that. I cannot take it further than that.
Going back to the same decision of the Reverend Chikane matter, in your affidavit, you informed the Commission that subsequent to that decision of pending the prosecution in the Chikane matter and further prosecutions in other TRC-related matters. You then only came or came to deal with the TRC cases during 2006 when you were appointed to chair the task team.
Yes, that's
Yes,
correct.
Yeah. And I think we can accept that from November 2004 until October 2006, as you stated in your affidavit, that was the first meeting that took place. There has never been any engagement regarding the prosecution of or investigation of TRC cases, isn't it?
Well, remember, I was also the Deputy National Director responsible for the PCLU. So the work continued. They continued going through, going through the dockets, as it were.
But on your own version, you suspended, you placed the moratorium on the.
On the prosecutions, not
Yes.
on doing work on the cases.
All right. We can then go to the domination of the Chikane matter in the meetings.
Yes.
You remember, you testified that the Chikane matter actually was a cause of concern for the meetings, as you said.
Yeah, that was my view. That was a view that I formed, yes.
Yes. Do you remember as to which of the meetings were characterized by the discussions around the Chikane matter?
The third meeting, I think, after the audit report was tabled at the meeting, at the second meeting.
So that would have been the 6th of November meeting?
Yeah, I think so.
6th November 2006.
Yes. Yeah, after the meeting of the 25th, I think, after the meeting of the 25th of October.
Commissioners, meeting of 6th November is PCJ 6, it's on page 1735.
I do have it, don't worry.
You have the minutes?
Yeah.
And you were the chairperson, you were present in that meeting, isn't it?
Yes. Oh, sorry.
You were not.
Sorry, let me just check and verify. No, I was present initially at the beginning of the meeting,
Yes,
but I asked to be excused because I had another meeting with the NDPP.
indeed so.
I think it
yes.
was chaired by Mr. Ngidi from the DSO.
Thank you, that's,
Yes.
that is what is reflected in the minutes. Would you agree with me, these are the only, or these minutes reflect the first time in which the Chikane matter was discussed
Was
in the
raised.
context, was
Yeah,
raised, yes.
yeah.
Yes. Now, your evidence to say that the Chikane matter dominated the meetings of the task team cannot be correct.
Just
You said the Chikane matter dominated the meetings of the task team.
yeah, subsequent meetings of the task team, starting with the meeting of the 6th of November.
Meeting of the 6th of November, perhaps if I may take you specifically to page 1736 of the bundle that is in front of you of
Yes.
PCJ 6.
Yes.
Can you read out where it says, according to Advocate Ackerman, the complainant? That's now the, I think, third paragraph from the
Yes,
last
I
one.
can see that.
Can you just read it out?
Yeah, according to Advocate Ackerman, the complainant, that is Reverend, indicated that he leaves the matter in the hands of the NPA. It was then decided that the latter's attitude be ascertained and the matter was therefore closed pending a feedback on his attitude.
Yes. So we can accept that during that meeting of the 6th of November 2006, the meeting resolved that the matter be closed pending consultation with Reverend
Yeah, I
Chikane.
mean, that was to dispel any notion that Reverend Chikane did not want the prosecution.
Yes,
Yeah.
but that was,
Yes, yes.
yes. And the only time this Chikane matter was discussed subsequent to that was during the meeting of the 29th of January 2007. Would you agree?
I just need to check again, but I do think that it was.
That's
it was,
PCJ 11.
It was mentioned again. Let me just see. I just want to check. May I just, it's just, but I do recall that it might not appear in the minutes, but I do recall that it was raised again.
In which meeting, Dr. Amaide?
It was the next meeting, that would have been the meeting of the 16th of November.
The meeting of the 16th of November is PCJ 9, and the minutes are recorded from page 1750 of the bundle in front of you.
Yeah, but I'm now speaking from my own recollection, because I do recall that that was not the only time that the Chikane matter was raised, so it kept on arising.
But I can confirm that in terms of the meeting that you said was subsequent to the 6th of November, that was on the 16th of November 2006, the Chikane matter was never discussed.
No, but I'm saying, I recall the matter arising again
Where?
at the next, at the subsequent meeting, and that would have been the meeting of the 16th.
But it's not recorded. In fact, Advocate Ackerman, during his cross-examination, he admitted that the Chikane matter was only dealt with on the 6th of November and the 29th of January 2007.
Well, I cannot explain, but I do recall. I may be wrong in my recollection.
But we can accept that on the basis of the minutes that are in front of the commission, the 16th of November, there is no talking about
It's
the
not
Chikane.
recorded, but as I say, I'm talking from my own recollection.
And you can also go to the meetings of the minutes of the 4th of December 2007. That's PCJ 10, page 1752. And you were the chairperson of that meeting, or you were present?
Yes, I was present.
Yes. Again, perusal of those minutes revealed that no such discussion about the Reverend Chikane matter ever took place.
I accept that.
You would accept that. And then we can go to PCJ 11, that's on page 1753.
Yes.
You see that's a meeting of 29th January 2007. And you were not present
I
in
was
that meeting.
not present at that meeting.
And you can see from the minutes, if I take you to paragraph, I think the third one there, the one that starts with Advocate Ackerman has requested members of their inputs,
Yeah.
for their inputs, you see there. That's when the issue of Commissioner Jacobs discussing the Chikane matter arose
Yes.
once again.
Yeah, I see that.
So we can accept that on the basis of the records that are before the commission, the Chikane matter was discussed only on the 6th of November by the ITT and the 29th of January 2007.
I accept that.
You also stated in your affidavit that there was a meeting that took place in early December 2006, where
Yes.
Commissioner Jacobs spoke about the National Commissioner's view and
Yes.
and lack of willingness to assist with.
Yes.
Yes, and that takes us back to the paragraphs that I canvassed with you earlier, your paragraph 42, 43, and
Yes,
44.
yes.
Yes. Now, I wanted to understand, what meeting or which meeting was that?
Sorry?
Which meeting was that?
The
The
meeting-
early, because in your affidavit, you talked to early December.
Yeah, I mean, I think I
Which meeting is that, was that?
At the time that I did the affidavit, I did not have any documentation, but that would have been the meeting of the 4th of December.
But the meeting of the 4th of December doesn't say anything about Commissioner Jacobs expressing any view of the National Commissioner.
It does not, but I still maintain that he did. He did, in fact, raise that issue, and I then subsequently reported it to the National Director of Public Prosecutions, Mr. Piccoli.
But if it was raised, why was it not recorded in the minutes of
I
the
cannot,
4th?
I cannot explain that.
Commissioner Jacobs testified before the commission that no such discussion took place during that meeting.
Well, but I maintain that he did. It arose. He did, in fact, raise it. And that is why I then went to report it to Advocate Piccoli. And I requested Advocate Piccoli to take the issue up with the National Commissioner, which I believe he did.
Evidence before the commission about Advocate Piccoli taking up the matter with the National Commissioner emanated from the discussions between General Jacobs and Advocate Mthunzi Mohaga on the 6th of December 2006 about the National Commissioner's view.
By the 6th of December, I had already reported back to the National Director.
Were you finished with the minutes of the meetings after the sitting of the minutes?
After the...
After the sitting of the meetings?
Yeah, the minutes were circulated, but I mean, that was a long time ago, so I could not recall the content.
Yeah. No, I'm interested to know if the minutes of the 4th
Of
of
the 4th.
December, yes, among others, were circulated after the meeting had set.
Yeah, they would have been circulated. They would have been circulated, but I don't think that they would have been circulated immediately, because what I seem to recall, and I stand to be corrected, I may be wrong, but what I seem to recall was that there was a toing and froing around the content of the minute of the final minutes between Mthunzi and Commissioner Jacobs.
Yes, but when you saw the minutes of the 4th of December not reflecting that which you are saying to the commission today, that was the view expressed by Commissioner Jacobs.
No, but the minutes only came much later. I had already reported that incident, that issue to Advocate Piccoli.
So you insist it was discussed on the 4th of December?
Yes, after the meeting.
After the meeting?
Yes.
Was it during the meeting or after the meeting?
No, after the meeting, at the end of the meeting, when the meeting closed, I then went to report to Advocate Piccoli, because it appeared that we were not going to get any resolution.
So this matter was discussed on the 4th, but it was not recorded in the minutes?
Yeah, that's what I said. I cannot explain why it does not appear. But I'm adamant that that issue did arise, and I did report it to Advocate Piccoli.
We can accept that your recollection is not supported by any evidence other than what you say you can recall.
Yeah, but I'm adamant that it did arise.
And then the same minutes,
Of?
Specifically, if I may refer you to the minutes of the 16th of November, 2006.
16th.
16th, yes,
All
the
right.
ones
Yeah, I've
appearing
got-
on page 1750 and
Yes.
1751.
I do have.
Specifically, if you go to page 1751. And then the paragraph, the second one from bottom. And can you read out what is
That
written there?
Mthunzi and Commissioner Jacobs undertook to compile such a report with a view of identifying cases for appointment of investigating officers by SABC, as Commissioner Jacobs indicated that he, Commissioner De Beer, has undertaken to appoint an investigators for all cases.
Thanks. And then maybe just go to the one second from bottom.
It was agreed that the task team has indeed made progress, as there were already cases identified for investigations and interim recommendations made on some cases.
Yes. And you chaired that meeting. You were the chairperson of that meeting.
Let me just verify, yes, I did.
Yes. So we can accept that on the basis of what is recorded there in the meeting that you were also present
Yes.
in, it was agreed by the meeting that there was progress made insofar as the provision of investigative capacity was concerned.
Yes, insofar as the provision, but whether in
Yes.
fact that capacity was provided subsequently or not, that's a different matter.
We're not talking subsequent. We'll get to subsequent. We're talking
Okay.
to that which is recorded that as at 16 November,
That is correct.
you were
yes.
satisfied
As-
that there was progress
yes,
being made.
as on that date,
Yes.
yes.
So the meeting of 29th of January 2007, you can't talk to that because you were not present. We can, and the view expressed by Commissioner Jacobs, you said it was during the meeting.
Sorry?
The views expressed on behalf of the National Commissioner by Commissioner Jacobs, you said they were presented during the meeting. It was not outside the meeting. In other words, what Commissioner Jacobs said was the view of the National Commissioner. So I'm trying to ascertain that you said that was communicated to you during
During the meeting, yes.
the meeting, okay.
Yes.
So you did not have any interaction with Commissioner Jacobs outside the meeting?
Yeah, look, I mean, I could have, we did have some discussions at a later stage. Yeah.
Okay. And then maybe if then I take you to your concluding paragraphs in your affidavit.
Yes.
I think that's paragraph 50, if I'm not mistaken.
Paragraph
50.
50. Let me just-
24, yeah, it's in the bundle that is before you, Ramaite bundle, 246, in your affidavit.
I'm just trying to, I put it aside, can you just, what page is it, by the way, sorry?
Page 246 of SAPS index cross-examination of Dr. Ramaite. Yeah, page 246.
I'm so sorry, because I had, can you help me again, because I had closed it when I was, oh yeah, it should be, oh yeah, there it is, I think. Thank you. Yes.
Okay. You stated in paragraph 50 that you regarded imposition of a moratorium by the executive as political interference, correct? And then you went on to paragraph 51 and 52 to testify about encroachment into prosecutorial independence.
Yes.
Just to confirm that the South African Police Service was not part of this political interference that you're referring to. Is that not so?
Yeah, look, I mean, I was very careful not to, because, this, and I may be wrong in this, talking about political in the broader sense. And I think I was talking about it in the form of executive interference, and mainly because, in other words, the executive will be part of the political arm of government.
Who would have been the executive in this context?
It would have been the head of the South African Police Service, who is part of the Ministry of Police, and the Director General of NIA.
And if you can be specific insofar as the executive on the part of the South African Police Service, who was that executive and what role specifically did that executive?
That would have been Mr. Psilevi.
The records before the commission show that the late Commissioner Slebe was the National Commissioner of the Police, not the Minister of Police. She was not
No,
part of
I'm
the
not
executive.
talking about the Minister of Police. I'm talking about, he was the administrative head of the department.
So he was not part of the executive that you're referring to.
Yeah, well, I mean, I considered him as part of the Ministry of Justice.
How could it be so when he was the National Commissioner of the Police? He was the accounting officer, just like the NDPP was in charge of the
No,
prosecution.
but he had no business in the prosecution decision making.
I'm referring to what is stated in paragraph 50. And I want us to agree that the late Commissioner Slebe could not have been part of the executive that's been referred to, Dr. Maite. He was not part of the executive.
Yeah, well, I mean, you know, I mean, my view is he was part of the executive arm of government.
Perhaps if you may assist in terms of what your understanding is in terms of the composition of the executive.
Well, it consists of cabinet ministers.
Yes. So National Commissioner was not. Even to date, the National Commissioner is not part of the cabinet ministers.
Yeah, okay, I
Yes.
accept that.
So we can agree that if at all your interference or political interference referred to members or executive members being involved, it could not have included the National Commissioner of the Police.
I accept that.
And we can also accept that you pointed out correctly that the National Commissioner was the head of the police. Is that not so?
Yes,
And he was in charge of the police service.
yes,
He was the accounting officer for the police service. Is that not so?
yes.
Yes. So meaning anything that had to do with policing, the NPA would have to discuss it with him as the relevant official that was in charge of the SAPS. Is
Yeah, but
not
that
so?
will not include prosecutorial decision making.
I accept that.
Yes.
But that we spoke of investigation,
Yes.
and the investigation would have fell under the National Commissioner. Is that not so?
Well, it would fall under the police, of course, ultimately the National Commissioner. But what we required was the provision of investigations, not decisions regarding, you know, the prosecution itself after the completion of the investigations.
We can accept that, yes. But what I was asking you was that insofar as investigation of cases was concerned, that fell within the purview of the National Commissioner.
That is correct, yes.
So it would not have been wrong for the National Commissioner of the Police to interact with the National Director of Public Prosecutions regarding...
Yeah, interaction broadly, you know, but specifically insofar as it relates to prosecutorial decision-making, no.
Yes, because you derive your powers from, or you derived your powers from the National Prosecuting Act.
And the Constitution.
Yes. And likewise, the National Commissioner also acted in accordance with the Constitution and the South African Police Service Act.
Insofar as investigations are concerned.
That is correct.
Yeah.
We can agree on that one, yes. Perhaps just also one thing that I needed to clarify with you, in paragraph 23 of your affidavit,
Yes.
you spoke of a transfer of dockets, about 400 dockets
Sorry,
that were
23.
transferred.
Yes.
Yes. You see where it is stated that some 400 or so investigation dockets were transferred to the PCLU. Advocate Ackerman, SE, and Chris McAdam, who was assigned as Deputy DPP in the PCLU, conducted an initial audit of TRC-related cases and identified some 21 cases which required further investigation.
Yeah.
Yes. I wanted to understand investigation dockets. What is meant by that?
Well, investigation dockets are dockets in respect of which no final decision on whether to prosecute or not has been made, and basically still under investigation. They cease to become investigation dockets once a decision whether to prosecute or not to prosecute has been made.
Advocate Bulelani Nguka, Advocate Pikoli, and Advocate McAdam testified before the commission that some 400 plus dockets at some point were taken to the police during the time when Advocate Bulelani Nguka was still the NDPP.
Yes.
Do you know about that?
Yes, that was the time. That happened during the time I was DPP.
So you know about those?
Yes, I know about those.
Advocate McAdam, in his evidence before the commission, he testified that the reason why those dockets were transferred to the police is because there was no action, no further action required at that time.
No. Well, I think Advocate Pikoli would have spoken about that because he was present when the dockets were actually handed back. And that arose from some allegations that amongst those dockets were the dockets involving the so-called ANC 37.
Yes.
And there were accusations that the NPA wanted to actually proceed with those prosecutions. And there was a direction that those dockets should actually be returned in order to address those allegations.
Be returned to who?
To the police.
But you indicated in your affidavit that the matters, TRC-related matters, have always been with or housed at the NPA.
No, there were dockets that were already in the NPA, in the DPP's office, arising from the Goldstone Commission. All right, now those dockets were being investigated. I think it was, I don't know whether he was a brigadier or a captain, Bretz, all right?
Senior Superintendent Brett.
Yeah, Senior Superintendent Bretz. And he was based at the DPP's office in Pretoria, where I was the DPP at that stage.
So we can accept that those dockets were housed at the DPP's office?
They were housed at the DPP's office, but they were under the care of this Senior Superintendent Bretz.
Who was seconded to assist, isn't
He came with Dr. De Oliveira from the Goldstone Commission, I believe.
And Senior Superintendent Brett was reporting to who at that time in terms of progress?
Well, I am not so sure because I never interacted with him. In fact, when I was appointed DPP. As far as I can remember, he was interacting, I think, with Ackerman and Paul Fick.
Okay. So we can accept that he was not reporting to the National Commissioner insofar as the investigation of those cases.
Well, he was. Well, yeah. But I mean, I cannot speak on that because I do not know.
Okay. One last thing. Do you know perhaps what was the reason for the ITT not to continue with its work following the meeting of the 29th of January 2007?
I do not know. What I do know is, well, I mean, we tried to implore upon the NDPP to try and resolve the impasse with the National Commissioner. I don't know, but what I subsequently gathered was that that was the last straw in the whole thing, and after that, there was no agreement as to the provision of investigative capacity.
What impasse was that?
In respect of the provision of investigative capacity.
No. I'm trying to understand as to why from 29 January 2007, the ITT never carried on with its work. Remember, you were the chairperson of the ITT.
Yeah, I mean, there was no agreement on the role of and functions of the task team, and then particularly in relation to the decision-making process, rather prosecutorial decision-making process.
So there was no agreement on the role of the ITT?
Yeah, there was no agreement.
Between who and who?
Between us, well, particularly me and Anton Ackerman and the representatives of the police, and I would say that was Commissioner Jacobs and just rather Likalakala.
Okay. Pursuant to that disagreement, what happened or what steps did you take to deal with that which you term as impasse?
But as I say, I reported it to Advocate Pikoli and implored on him to take it up with the National Commissioner.
And what happened afterwards? Did you follow up with Advocate Pikoli? As to
Yeah, we did follow up, but I mean, it was never resolved until Advocate Pikoli left.
the evidence that is before the commission, which was confirmed by Advocate Pikoli, is the letter that he addressed to the National Commissioner. I'm sorry, the National Commissioner addressed to Advocate Pikoli.
Yes.
Perhaps if I may assist you, that's PCJ.
Sorry, it's PCJ what? Sorry.
I'll just give me a few minutes, sorry about that. It would be PCJ 13, and in the bundle before you, that's Jacob's bundle. You can go to page 1756.
17?
56.
17, sorry?
1756.
1756.
Yes.
Oh, all right. Sorry, I'm sorry, I did not hear you
No problem, sir.
correctly. 1756. Yes, yes, I've got it.
And then there's another letter that appears as PCJ 14. Just after that
After,
one, it would
okay.
be on page 1758,
Yes.
addressed to Advocate
Simelane.
Menzi Simelane.
Yes.
Then after that one, there's another one, PCJ 15, appearing on page 1760. It was addressed to the late Mr. Manzini
Yes.
of National Intelligence Agency. And all these letters are framed, well,
In a
they're written
similar
in the
vein.
same similar version, yes,
Yeah.
yes. And essentially what is communicated to Advocate Pikoli by the National Commissioner is that which you probably refer to as an impasse. If perhaps I may just give you...
Yeah, yes, yes.
Yes. So we can accept that this impasse or alleged impasse wasn't just between the SAPS and the NPA. It would have extended to the Mr. Menzies Melani, Mr. Manzini.
Yeah,
And
who
so-
were actually the principals of the task team.
Yes.
Yeah.
Yeah, meaning the confusion was not confined to the NPA and the police only. It would have extended to other role players.
Yeah,
as well.
I apologize if I created the impression that it was confined to Mr. Silevi, but that was not what I intended
Okay.
to say.
And then, yes, thank you for that. The response perhaps of Advocate Pikoli to the letter by the late National Commissioner appears as PCJ 16, that would be page 1762 of the same bundle that's in front of me, the Jacobs bundle.
62,
62.
yes. Yeah,
Perhaps if you may just read out where he says advice, you can confirm that that letter was addressed to Mr. J.S. Silebi, right?
yes.
Yes. And then it's dated 6 February 2007, which was the same day on which the letter of National Commissioner was written to Advocate Pikoli.
Yes.
Yeah. So perhaps if you may read out, I advise that, perhaps just to read
I
it out.
advise
for-
that it is clear that our understanding of the mandate of the task team as well as the guidelines that Cabinet approved are not the same. In the circumstances, this matter as well as other issues that have emerged in the course of the NPA dealing with the TRC cases are currently being taken up with the Minister of Justice and Constitutional Development.
Yes, he would take the matter up with the minister, isn't it?
Yeah, I see that from the letter.
Yes, you see it in the letter.
Yeah.
Yes, and he confirmed during his testimony that indeed he was going to engage the minister.
Yeah, I have no reason to disbelieve that.
Yes, indeed. Now, going back to your paragraph 50,
Yes.
where you said the involvement of the executive, in your view, meant political interference. What do you make of Advocate Piccoli, who was the DPP at the time, undertaking to engage a member of the executive regarding the issues or the impasse between?
Well, I can only note that. I mean, that's what happened. I don't think I can say anything in that regard.
But we can accept on the record that it was the Advocate Piccoli who actually undertook to engage
I accept.
the minister.
I accept.
We cannot dispute that. Commissioners, that brings an end to cross-examination on the part of the SAPS.
Thank you, Ms. Ranto. Mr. Soni?
Chairperson, Commissioners. Just a few issues that arise from the evidence, Chairperson. Dr. Ramaite, a fair amount of evidence has been given in this commission relating to the documents that constitute annexures to Mr. Jacobs's affidavit, and that's the PCJ 1 to, I think, 15 or whatever it is. You've had that, you have that pile with you. The PCJ documents.
Just locate it.
These are the minutes of, or part of them are the minutes of the meeting of the task team.
Yes.
Now, one of the issues I'd like to raise with you is this. We had assumed, well, firstly, you accept that it was Advocate Mahaga who compiled the minutes.
Yes. Yes.
And you accept that for the most part we can accept the minutes as correct.
Yes.
Can I then ask you to please look at PCJ 3?
3. Yes.
Now, this is the first meeting of the task team, and it was addressed, as you'll see, in the after the names of the persons who were present, it was addressed by the then NDPP Advocate Piccoli.
That is correct.
All right. Now I ask you to look at around line 10, and well, perhaps let me just ask you, one of the purposes of the task team, and I'm not saying it was the only purpose, was to work out how it is that the prosecuting authorities would be given investigating assistance.
That is correct.
All right. So if you look at around line 10, and I'll just read it to you, it says, SAPS has to provide investigating officers for all cases identified for prosecution.
That is correct.
You see that?
Yes.
And I take it that it would be a fair assumption that one of the purposes of the task team was to ensure that a mechanism was achieved whereby that investigating assistance was given.
That is correct.
Right. Now, the task team we know met for the first time on the 12th of October, and the last time on the
I think it's the
29th of January.
Yes.
So about 4 or 5 months.
Yes.
Okay. Now, You were the chairperson of the task team. You'd been appointed by Advocate Pikoli for this purpose.
That is correct.
Now, before I get to the task team itself, I just want to raise with you paragraph 23 of your affidavit, please.
Close the thing. Let me see. So yeah, I closed it again, so I'm just trying to find it. Oh yeah, there it is. Okay, we've got it. Thanks.
All right. So
Yeah, sure.
at paragraph 23, and just to facilitate this interaction, I'm just going to read some parts of that paragraph to you. It says, some 400 or so investigating dockets, that's in the middle of that paragraph, were transferred to the PCLU. Advocate Ackerman and Chris McAdam, who were assigned as Deputy DPP in the PCLU, conducted an initial audit of TRC-related cases and identified some 21 cases which required further investigation.
Yes.
Right. Then the next paragraph goes, although I was not involved in the day-to-day operational activities of the PCLU, Advocate Ackerman kept me abreast of the work of the unit by way of monthly reports.
Yes.
Now, these monthly reports, I take it, would have been filed at the offices of the PCLU.
Yeah, yes.
And then it says these reports were tabled and discussed at the monthly meetings of the EXCO of the NPA, which was chaired by the NDPP and made up of all the DPPs and SDPPs.
That is correct.
What I want to ask you is, was this only at the time of Advocate Nguka, or was it also at the time of Advocate Pikoli? These
mean
monthly meetings.
The meetings, no, during, well, yeah, Advocate Muka as well as Advocate Pikoli and other NDPPs.
So, if we want to know what was discussed by the NPA on a monthly basis, we would be able to go to those monthly meetings.
Yes.
Who kept those records?
I think it was the office of the NDPP at that time, at that stage. I think it was the chief of staff of the NDPP.
Who was who?
Oh, I cannot recall. What was his name now? Oof. I cannot remember his name now. It's a long time ago. I think he left soon after I left. Danny. What was his name? Danny. But his name was Danny. I remember the name Danny. I cannot remember the surname.
But you say
Danny Schmidt.
Danny Schmidt.
Smith. Is it Smith or Schmidt? I think it's Schmidt.
All right, but you say he was the chief of staff of
the
all
ND
the NDPPs.
Yeah. During Mr. Pikoli's time.
And during Mr. Nguga's time?
Oh, phew. No, I cannot remember.
You were the supervisor of the PCLU until you were removed from that position by Advocate Nkosana.
Yes,
That's according
yes,
to your
yes,
affidavit.
yeah.
When was that?
Soon after his appointment. No,
That would have been around 2013.
yeah.
Okay. Now, you would have attended all those meetings.
Yeah, as now I was actually moved to, he asked me to move to the the NPS,
Yes,
you know, because of performance problems that they had there.
To supervise the
To
DPPs.
supervise the DPPs.
That
yes.
was in 2013.
Yes.
But I'm saying from 2003 to 2013, period of about some years, some 10 years, you were the oversight person in respect of PCLU.
That is
matters.
correct.
Now, in paragraph 23, you say they conducted an initial audit.
Yes.
This is Mr. Advocate Ackerman and Advocate McAdam.
Yes. that is-
Were any further audits conducted?
Well, I mean, I think that was in essence a formal audit to determine the volume of work that we had. But after they had identified the 21 or so cases, they did identify a further, but I think it was less than the previous cases that they had identified. I cannot remember the exact number.
See, I'm asking in this context, the PCLU is now established by the President in 2003. I think it's March or so. And then in October, the then NDPP, Advocate Nguka, decides that TRC cases will be priority crimes and they will be handled by the PCLU.
Yes.
Right. Now I'm asking, as I understand it, those matters were in the different regions initially.
Yeah, well, I would say that the majority of them were in the DPP's office in Pretoria because they came from the Goldstone Commission.
Yes.
But there were others in other DPP offices, and I remember particularly in the Eastern Cape there was some.
Okay. The question I'm asking is, an initial audit is conducted, that's the one you refer to in paragraph 23.
Yes.
To your knowledge or to your recollection, were further audits conducted?
No, not thereafter. Except
Throughout,
except for the audit that was conducted during the task team's time.
That's what I'm asking. So this audit that you're talking about was during the period of the task team,
No, the initial audit was before that.
right?
Yeah.
And then there were further audits.
Yeah, there was now there was the audit during the time of the task team, and the purpose of that, or the reason for that, was to identify cases so that there would be agreement between the police in particular and the NPA as to the sort of number of investigative capacity that would be required.
The post-TRC cases would fall into two categories. Would I be correct? Well, let me tell you what the two categories are, and you can tell me whether I'm correct or not. The one is those persons who were refused amnesty.
Yes.
And then the second would be those who were not, who did not
apply for amnesty,
who
yes,
in fact treated the TRC process with contempt.
Yes.
All right. Was any mechanism created at these meetings, these monthly meetings, to work out how many people would fall into the category of those who were not granted amnesty, and how many would fall into those who didn't apply for amnesty, but appear to have been implicated in abuses of the past?
Well, I cannot tell. I mean, but it's because the cases were transferred to the office of the NDPP whilst I was still the DPP. So it is likely that that process could have taken place before I went to the head office. But I do know that at the time that the process was continuing, even at the time that I was a special director in the office of the national director and special advisor to the national director.
Let's get back to paragraph 23.
Yes.
You say that Advocate Ackerman and Advocate McAdam conducted an audit. Were you there when that audit
Oh,
was
sorry,
conducted?
I think I might have missed it. Now, that would have been May 2003.
That's the time
And that
you
would
were
have
with the
been
PCLU.
after the PCLU had been established. Yes, all right, okay.
So that's the audit I'm talking about.
Yes, yes.
All right. And the mechanism of the categorization of cases that the PCLU or the TRC unit of the PCLU would deal with, you would have been there as well.
Yes,
To
yes.
work out how many.
Yes.
During your time, was there a list of these are the cases of people who were refused amnesty, and these must be investigated, and these are the people who didn't apply for amnesty, and those matters must be investigated?
Yeah, I cannot recall, but you know, I do not remember seeing, you know, a separate category of those who applied for amnesty and were not granted, and those who did not. Who did, I do not recall. I think Advocate Akban will be better placed to deal with that.
I asked this question, Dr. Ramaite, for one reason. You were the person who oversees the work of the PCLU. You've got very senior people in the PCLU, including Advocate Ackerman and Advocate McAdam and Advocate Pretorius. Am I right?
Yes.
Now, how would you say that this unit is performing well if you don't know how many cases or how they established what cases they are going to be dealing with?
No, I knew from the reports, and before the reports were presented at the EXCO, we discussed the content of the report and went through the work that they were doing.
No, that's the quality of the work. I'm looking at the quantity of the work, the number of cases that they would be dealing with.
Yeah, but as I state there, you know, I mean, initially they went through this 400 or so dockets, and then they narrowed it down to the 2021.
So there was no list. I mean, they didn't add to those cases that they subsequently would have discovered or uncovered as certainly those people who had not applied for amnesty.
After the 21 cases, there was, as I say, and I'm no longer so sure about the number, but it would have been 16 or so further cases that were identified. So in other words, I mean, the process went like this. They first had a look at those cases where in fact we're not going to require any investigations. In other words, which had to be, you know, I mean, which were eventually closed, okay, because I mean either the suspects have died or there was insufficient evidence, and then the second part of the process was to identify those that required further investigations. And then the third part will be those that were ready for enrollment or for prosecution.
Who compiled that list?
That was the PCLU, Advocate Ackerman and McAdam.
Is there such a list?
Yeah, they should be.
Did you ever see such a list?
Yeah, during my time, yes.
And it would have been presented at these monthly meetings.
Well, look, I mean, the reports at the monthly meetings will not be as detailed as to contain attachments like lists of cases.
Does it not surprise you so that you would have these important cases, which are all priority crimes, but you don't have a list of cases that should be considered by the PCLU?
Well, I mean, as I say, my recollection is that there was such a list.
if you can't give us that, who can? That information.
Well, that would be, you know, in the NPA. I mean, I did not take anything, any documentation with me when I left, so I cannot. That would be the NPA, I suppose.
Now, one of the issues that was discussed in the task team, and that was raised with you, I think, by my learned friend for the SAPS, Ms. Ranto, was the meeting of the task team, or
Yes.
the meetings of the task team.
Yes,
And I've already established with you that one of the purposes was that there would be investigators
Yes.
that would be involved. I want to go back to your affidavit and ask you to look at paragraph 44, please.
sorry, paragraph
44.
44. Yes,
Now, you'll see there, and we don't need to read the whole thing. In that paragraph, you mention the meeting of December 2006.
yes,
I take it that's the meeting of the 6th of December that that you were already referring
that would
to.
be the
or
4th.
4th of December.
yes.
Yes. Now, you don't mention any further meetings of the task team in your affidavit.
Yeah,
I just want to take you to the last two meetings of the task team.
yes.
And just remember, keep in mind the issue I'm raising, the context in which I'm raising this. The purpose was to find investigators to assist the PCLU with its work so that prosecutions can take place.
Yes,
Now, can I ask you to please look at PCJ 10, which will be on page 1752 of that bundle,
1752.
and it's the meeting of the 4th of December 2006. And you'll know that the 2007 has been
Yeah.
changed to 2006. Now you'll see there that in the third last paragraph, there is, and it's in handwriting, paragraph 4.5, Commissioner Jacobs informed members that he has sent a letter to Commissioner De Beer and the list of all investigators will be ready soon.
Yes,
Did that happen?
no, as far as I can recall.
No, no, no. I'm asking a different question. Did he say this at the meeting?
No, did he say? Sorry?
Yes.
Yeah, he did.
You did.
Yeah.
Okay. Now, that must have been music to your ears because it means now that the TRC process is going to start with momentum.
Yes,
Because
certainly.
the investigators are going to be provided.
Yes, yes.
All right. So you would have been waiting in anticipation for that.
Yes.
Now ask you then to turn to page, the next page, 1753, PCJ 11.
Yes.
Now ask you to then look at the fourth paragraph from the bottom, where it said, Commissioner Jacobs informed the meeting that he has gone through the docket on the, the second last paragraph. It
Yes.
says, Commissioner Jacobs informed the meeting that he is waiting for a feedback from provincial commissioners on the appointment of investigators. Some had responded and provided him with a list of investigators. He also requested a list of SAPS dockets in possession of the PCLU. Were you aware of this?
Of what he informed the meeting?
Yes.
Yeah.
Were you aware of it?
Yes. That he informed the meeting about about waiting for a feedback.
Yes, but
Yes.
you'll recall that you were not at the meeting of the 29th.
I remember it from, I recall it from the report that I received from Advocate Ackerman. And I don't know who chaired the meeting, but I definitely became aware of it.
Okay, so Commissioner Jacobs gave meeting and he presented these letters that he said had been sent. You aware of that?
Yes, although I was not at the meeting, yeah, I became aware of it.
Yes. Now, as I understand it, you say now that these investigators were not made available.
That is correct.
The question I want to ask you is, what did you do about it?
Well, again, I mean, we returned to the national director, and then we asked him to intervene. Yeah,
This is in January 2007.
yeah,
Advocate Piccoli leaves in September 2007.
yes,
Nothing happens, as I understand it then, between January 2007 and September 2007 in regard to the provision of,
yeah, nothing happened.
and what did you do during that period?
Well, I mean, again, after I cannot remember who actually acted after Mr. Piccoli left. I'm just trying to recall, but yeah,
I think it was Advocate Chair.
yeah, it was Advocate Pierre. Yeah, I mean, like investigative capacity, but then, you know, I mean,
Nothing happened.
Nothing happened. Yeah.
You are the head of an institution or oversee an institution that had been mandated, in fact required, to deal with TRC matters, a matter that was of immense interest to many victims of abuses of the past.
Yes, yes.
And nothing happens during that entire period, and nothing is done about it.
Yeah, and I mean that is unacceptable, wholly unacceptable, you know. But that is what happened.
See, the issue, and I raised this with Advocate Piccoli as well, wasn't it an institutional issue?
Sorry,
Was it not an institutional issue between the police on the one side and the prosecuting authority on the other?
it was.
Can I then ask you, just in regard to the success rate of successful prosecution in respect of TRC matters? I'm just going to put this to you. We've already established that you were the oversight person in regard to the PCLU from 2003 to 2013 when you were moved by Advocate Nkosana. I see you shake your head there.
No.
Does that mean
I'm
yes?
trying to
No,
listen
that's the question.
attentively. Yes.
I'm asking, is it correct that you were the oversight person for a period of 10 years in regard to
The PCL.
TRC matters?
Yes.
Now, Advocate Ackerman made an affidavit in the Nkadimeng matter on which he gave evidence and Advocate Piccoli gave evidence. Chairperson, it is FA 8 to the Nkadimeng 2 papers. Chairperson, it's been referred to on several occasions. I just want to say to you, Dr. Ramaite, that in 2015, he lists 4 cases that had been prosecuted by the PCLU. First case he lists is a case in 2003, the case which you would know about of Eugene Tablanche. The second case he says, that was in 2004, is the case of Blani. Third case he refers to, again in 2004, is the Gideon Niehout case, which was effectively, which is colloquially written, referred to as the PEPCO 3 case.
Yes.
And then the fourth case, of course, is the case of Minister Flock, Commissioner van der Merwe, and the 3 so-called foot soldiers involved in the Chikane attempted murder.
Yes.
Those were the 4 cases. Are
Yes.
there any cases that you are aware of that he hasn't referred to?
No, they are not.
Now, isn't that a poor record by any standard?
Well, indeed it is. It is. But I mean, again, those 4 cases that he mentions, they were the ones that were actually ready for prosecution because there had been, investigations.
They, though, were the only 4 cases.
Excuse me?
They, though, were the only 4 cases. During the entire period, you were the oversight person in regard to
Yes.
to TRC.
Yes,
matters.
yes.
And does that not reflect more than simply an institutional problem between the NPA and the SAPS?
It does, yes.
Now, one of the reasons that Reverend Chikane gave is that at this time, during this entire period, there was simply no appetite to prosecute these matters. I'm not saying he says it's the only reason, just understand my question.
Yes.
Is that an impression you got as well?
Well, I mean, I would say that from the viewpoint of the NPA and in particular the PCLU, there was no appetite. There was appetite, but I mean, again, they were hamstrung by lack of investigative capacity.
With all your enthusiasm, sir. With
Yes.
all the enthusiasm you can muster.
Yeah, I mean, there was certainly. My observation, and in particular, was that they were actually willing.
I have no questions, so no further
Thank you,
questions.
Mr. Soni. Commissioner Khomo.
Dr. Ramite, I want to deal with you briefly, and it relates to a confined period. You see, in your statement, I'm referring to the statement of the 26th November 2025, in paragraph 25, we know that you say Mr. Ncuka resigned in July 2004. That would be correct.
That is correct, Commissioner.
Yes. Now, I want you to move to paragraph 31 of the same statement. And we're looking at the fingerprints of attorney Wagner and the ramifications of his involvement. And we're going to deal only with paragraphs 31 to 34. So I want to read paragraph 31.
Chair, it reads as follows. Advocate Ackerman also informed me that soon after he had spoken with Wagenaar, he received a telephone call from an official in the Ministry of Justice and informed that a decision had been taken that the case involving Reverend Chikane should be put on hold pending the development of guidelines to deal with the TRC cases. I told Advocate Ackerman that I have no knowledge of the development of any such guidelines. As far as I was concerned, prosecution policy and guidelines already existed. The existing guidelines were developed in line with the United Nations guidelines on the role of prosecutors and applied and continue to apply in all cases involving the decision whether or not to prosecute and whether or not to continue or discontinue prosecution.
Yes. Now, in paragraph 32, you would see the ramifications now
Yes.
of what Ackerman conveyed, of what Wagenaar conveyed to Ackerman. And can you just read that for us?
It reads as follows. I advise Advocate Ackerman SC that it would be better to wait and have a better understanding of what exactly was happening. Shortly after I have spoken with Advocate Ackerman SC, I received a telephone call from the Minister of Justice, Mrs. Bridget Mawandla. She told me that there's a task team which was appointed by the Directors General Forum to develop a mechanism to deal with TRC cases. I expressed to the Minister my concern that any process or mechanism which involves the executive or the justice and security cluster would amount to encroaching into prosecutorial decision-making and will be a violation of prosecutorial independence as enshrined in Section 179 of the Constitution. The Minister nevertheless insisted that the prosecution of all TRC cases must be put on hold until the development and adoption of the guidelines.
Yes. 33.
33. Subsequent to my telephone call with the Minister, I called Advocate Ackerman and told him that I received an instruction from the Minister that the investigation and prosecution of all TRC cases must be put on hold pending the development and adoption of guidelines. I told Advocate Ackerman SC that my understanding was that an effective moratorium has been placed by government on all TRC cases and that until it was lifted, we have no choice but to wait.
Yes. Now, you acting on a verbal instruction, is that all that you acted upon? Minister Mabandla, before you conveyed this to Ackerman, had not given you anything in writing, and you did not demand anything in writing.
She did not give me anything in writing, but I did request her, and I recall this. I might not have put it. I requested her to provide me with that in writing, but she then said she will, but it never came.
But why did you act upon the verbal instruction? I mean, with the very firm and specific knowledge that you express in these paragraphs that you have read. Say to her, no, I'm not doing anything until I receive something from you in writing.
No, Commissioner, I kept on waiting, and I tried to call her office after that conversation, but the letter never came until I vacated my acting stint position.
And when did that remind us?
I think I
when
acted
did that
for about
act?
six months or so. 6 months, and could have been 6, 7 months. Yeah.
Yes. Okay. Then read paragraph 34. We concluding with that paragraph.
After the call from the Minister of Justice and my discussion with Advocate Ackerman, all TRC cases which were being handled by the PCLU were accordingly placed on hold pending the development and formulation of guidelines. My understanding was that the guidelines were in relation to cases arising from conflicts of the past. As I understood, they were to be incorporated as amendments to the existing prosecution policy.
Yes. Now, we learned, and you can see whether this is correct, the moratorium was lifted in 2005. Would that be correct?
Yes, that is after the publication and coming to operation of the amendments to the guidelines.
Now, let us just look at what everyone speaks of moratorium, but let us just look at what the definition of moratorium is. A moratorium is a temporary official suspension or delay of a specific activity, law or legal obligation declared by a government, business, or a government body. It essentially presses the pause button to allow time for review, crisis management, or financial recovery before normal operations resume. Would you argue against that definition?
No, I wouldn't. It's correct.
And to your knowledge, from the time that you had this engagement with Advocate Ackerman about what Attorney Wagner has conveyed to you until the upliftment of the moratorium, were there any prosecutions?
No, there were no prosecutions.
There were no prosecutions as a result of the moratorium. Otherwise, it wouldn't be.
Yes, that is correct.
Okay. Thank you.
Thank you.
And if I understand your evidence correctly, Dr. Ramaite, this also applied to investigations of matters which stopped during that period of the moratorium.
Yes.
Okay, thank you. Thank you.
Dr. Ramaite, thank you once again for having come to give evidence before this commission. You are now excused as a witness.
Thank you, Chairperson and Commissioners.
Yes. These proceedings are adjourned until tomorrow at 10 o'clock.
As you wish.